Next matter, case 12, line 1, last of Bivins, first of Michael.
Thank you.
And Your Honor, there are multiple victims, representatives of victims present on WebEx who do want to address the court at an appropriate time. When we get there, I'll probably call them out by name since we have so many to have them be able to address the court in order.
Thank you, Mr.
Assigned to
Gibbs. Thank you.
Mr. Bivins, my name is Zach Pedrassi. I'm going to help you with the arraignment that's scheduled for this afternoon. My name is Zach Pedrassi. I'm a court-appointed attorney. You don't want to have an attorney? Okay. I'll help you with this hearing. And I'll let the court know that you would like to represent yourself. There's some just sort of formal procedural stuff that I think is probably the best that I help us move through. Well, let me talk to the judge about that. I'll see what the judge has to say. Before we go any further, let me just confirm with Michael. No, I'm asking you. Well, no defense attorney here is here to help you with your arraignment. You don't want any assistance? You'd rather proceed on your own? Okay, I'll let the court know. Now, Mr. Bivins has said that he would prefer not to proceed with the help of counsel. I'll let him know that he has a right to have counsel assist him. And I understand this may not be the time and place to address that issue, but those are concerns being raised by Mr. Bivins.
Thank you, Mr. Bivins. At this juncture, you might be best served by at least having Mr. Pedrassi get through this proceeding. This is a very short proceeding, after which we can take up the issue of whether it's appropriate for you to proceed with an attorney. This is merely procedural, and this, although merely procedural, does have some meaning, and you want to get it right at this juncture. After this point, we can come back and we can address whether it's appropriate for you to defend yourself or take this case on. But for today, I'm going to have Mr. Pedrassi proceed, and I'll need your help if you would, please.
I mean, is it absolutely, like I was asking him, is it absolutely necessary for him to be here?
Well, I'm finding that it is, and the reason I am is because I have some profound doubts based on the charges that I've reviewed that it's appropriate to let you proceed without at least Mr. Pedrassi's help in this event. Okay?
Oh, no.
So, Mr. Bivins, all I need to do is enter a plea of not guilty, though, maintain the presumption of innocence, and get you a future court date. What's that? You can. Is there any reason why we can't do it together?
We have the proceeding forms.
There.
Imagine, Mr. Bivins, you trying to diagnose your own appendicitis. You have a side ache. You don't know what you got. You know you hurt. Would you do your own surgery? Probably not, right? Well, that's where we're at in this proceeding. And so for today, it's not in your best interest to proceed by taking out your own appendix. It might not be appendicitis. It might be something else. What was that?
Mr. Bivins is reiterating that he would prefer to proceed without the help of counsel.
Mr. Gibbs.
Your Honor, given that I think the court has the obligation to go through the pro se colloquy with the defendant. I believe there's a form for it, and if the defendant is making a knowing and voluntary waiver of that right, frankly, Your Honor, the Court of Appeals said that insisting that someone be appointed counsel when they're knowingly wanting to waive that right can be error just as much as not appointing someone counsel who wants it. So I'd ask the court engage in the inquiry on the form and see where we go from there.
Well, I'd like to. I'm not sure I have the form up here.
I think your clerk has a copy of that.
All right, thank you. Yeah.
I mean, if this is just a procedural thing, you can leave and then you can address, maybe in the future if it's impossible.
Well, that's what I would prefer to do, because if nothing else, you've had a chance to talk to an attorney and get a better idea of, at a later date whether you want to proceed. Otherwise, at this point, we're going through this long procedure, and I'm going to make a determination. And I could find at the end of 5 or 10 minutes from now that it's inappropriate to have you proceed without the assistance of counsel. And you can always readdress this at a later time.
Let's just get to that point where he can leave and you can make the determination.
Well, why don't you let him do the arraignment today, and then you can talk to Mr. Tran, and you can tell Mr. Tran, because Mr. Tran is the individual we're assigning to assist you, you don't want counsel, and he can bring up this objection at a later date. That's all.
This is basically a procedural thing.
Well, it's not. Okay, sir, if you'd like. All right, so you understand that you have a constitutional right to have an attorney in this case. Do you understand that, sir? And the court has been told to appoint a Mr. Tran to assist you. And you understand that you don't have legal training and experience, and you may not recognize legal defenses that may be available to you. The rules and procedures of trial will apply to you as it does any other individual with or without an attorney. And the state will be represented by Mr. Gibbs or someone like Mr. Gibbs. And you have to understand that without an attorney, you won't have someone to assist you in reviewing the facts of your case to determine what the defenses are, if any, and any identifying problems with the state's case. You also have to recognize that an attorney will be able to help you with that case. An attorney can help you in the plea process if a plea is appropriate, negotiate a plea agreement, apply to get released before trial. These individuals are all trained to assist individuals like you in accomplishing those goals. An attorney understands the rules of evidence and knows how to question witnesses and object or present evidence necessary for your defense, and that an attorney would be able to object to improper evidence being admitted by the state. An attorney can help you decide if it should, if you need a jury trial or if it's more appropriate to have a judge determine your case. An attorney can help evaluate and challenge those potential jurors that would sit on any jury that your case was presented before. An attorney knows how to make legal arguments to the court and present opening and closing arguments to that jury. An attorney can help you with your sentence if you're found guilty. An attorney can help present evidence and make arguments about those sentencing and whether it's appropriate or not. And an attorney knows how to get information from the prosecutor that will be important to your case, such as police reports and statements from witnesses. You must understand that the judge, the district attorney, and court staff and interpreter will not be able to give you legal advice along the way to assist you in defending yourself. And I presume you're not under the influence of any drugs or alcohol at this time?
Well, like I was saying, just because you made it seem like this is just really just, make a statement or whatever.
No, you don't make a statement. I
I'm
won't.
not statement, plea or whatever.
Well, what you're telling me, sir, is you're making a large decision for a very short proceeding. Okay? You can make this decision at a later date, but get more information to make an educated decision. Right now, you don't know the facts. Neither does Mr. Pedrazi. I don't know anything about it other than the allegations of the state. And at this point, any statement you made could be used against you, and Mr. Pedrazi's here to prevent that from occurring, and he's here to assist you. My point is, you have all of these rights to say no at a later time, but you might as well take advantage and get educated as to whether it's appropriate to have an attorney assist you. And now, and I can't give advice, is not the time to throw the baby out with the bathwater.
Is this would this be my dad the whole time? Or?
No, sir.
Well, if he's not going to be here for the whole
He's
time.
just here for a short proceeding. Imagine a nurse prepping your leg for surgery.
fall away. Mr. Tran, your point counsel, doesn't even that time still don't want help, then you've had a chance to listen to what your attorney has to say. The judge is going to be much more likely to dismiss your representation on later proceeding ground. So at least there's a chance to that and talk to them. Does that make sense? Maybe the short as soon as they can. So that's if your name, your birth is 1/1888. This is your date of birth. You hang on to this. That's the charging instrument. Put you on notice what you're being charged with. Your Honor, despite reservations, Mr. Bivins decided to proceed with my help for this hearing alone. Mr. Bivins is truly named the date of birth provided is accurate. Waive formal reading of the charging instrument and advice of rights. Reserve all rights as they're read onto the record this morning. Mr. Bivins is entering pleas of not guilty to the pending matters, requesting a return to court date, and asking that his case be referred to closed street supervision for evaluation only, and that his bail be reduced to the statutory minimum.
Thank you very much.
Counsel, this is non-BM 11.
Oh, this is not that development 11. Thank you. In that case, Your Honor, I would be moving for Mr. Bivins to be released to work with pretrial release. I see no criminal history here to speak of. I do see an address as well as a history here in the Portland area that would suggest that he has ties to the community and is unlikely to try and leave or abscond. And certainly from his presentation, it was clear that Mr. Bivins is very interested in addressing and resolving this case in a very personal way.
Thank you. Mr. Gibbs.
Your Honor, the bottom line from the state's perspective is we're recommending that security be set at $75,000. I'll elaborate further, but I did want to give the representatives from the various victims their opportunity to address the court on matters related to defendant's release. The people present on WebEx are Rabbi Kahana, Mia Burke, and Katie Schneider, who I'm going to ask to address the court in that order. Rabbi Kahana, if you could let the court know what you have to say at this time.
Thank you very much, Your Honor. Thank you for giving me an opportunity to speak. I'm Senior Rabbi of Congregation Beth Israel in Northwest Portland. Our community was truly shaken by that virulent Nazi-referenced anti-Semitic graffiti that was painted on the exterior of our historic sanctuary in yellow paint. This occurred only a few days after we commemorated Yom HaShoah, our Holocaust Memorial Day, and so the impact of this was to create a real mood of fear and concern in our community. And only a few days later, there was a follow-up with a rock thrown through the window of our synagogue's library. It is our understanding from law enforcement that these two events are linked, and from media reports that there are numerous crimes against houses of worship in our community. And this idea that this linkage is something that creates a great deal of fear and vulnerability in our community.
Thank you very much, Rabbi. Appreciate it, sir.
Ms. Burke, if you could be unmuted and let the court know what you want the court to know.
I am the co-founder and executive director of the Eastside Jewish Commons, which is co-located in the space on Sandy that was vandalized. We are representative of multiple co-located organizations, including more than a dozen Jewish community professionals, tutors, kids, parents, elders, counselors, and others who all come to use this space for activities. And our community is terrified, shaken up, and extremely worried to even come back to work at this point. We've been building this for many, many years, and we share Rabbi Kahana's concern about the linkage with Nazi symbolism, broken glass, and the ties to multiple, clearly what is a pattern of intentional destruction to communities of faith.
Thank you.
Ms. Schneider, if you could add your comments at this point, please.
Congregation Shir Tikva is the synagogue that's co-located with the Eastside Jewish Commons. We're the largest user. We have over 200 member families that come and go from the building. And what is noticeable to us is there is some level of monetary damage that for small organizations is burdensome, but it's much more about the psychological impact when there is somebody out there targeting vulnerable communities for what they believe and for who they are. It represents a real threat and a real danger to us. And I would just ask the court to take into account the psychological impact of repeated targeting of religious institutions and what that feels like.
Thank you.
Your Honor, the reasons articulated by the victims, as well as what the court has certainly read in the allegations in the affidavit of probable cause, we don't think conditional release at this point is appropriate. I particularly draw the court's attention to Mr. Bivins' alleged statements that he continued to expected to continue victimizing other communities in the statements that he made to the witness that were recorded. Given the primary and secondary criteria, I think public safety and victim safety requires a conditional release not be imposed. Turning to security, Your Honor, as counsel noted, I certainly recognize that this defendant has no prior contact with the system and no prior record. Given the nature of the allegations, though, of course, and presentation in court, I certainly do have some concern about him appearing. I do think that the security in the amount of $75,000 would be sufficient to assure his appearance were he released from custody. Additionally, I'm asking that if he is released for any reason, that he report immediately to closed street for supervision, and that he not enter within 150 feet of Congregation Bet Israel, Congregation Shir Tikva, Everybody Eats PDX, and the Muslim Community Center of Portland, who are all the victim entities identified in the charging document.
Thank you. Any response, counsel?
Well, my only response is there's a preference for release, Your Honor, expressed by the state legislature. The lease owner's means to encourage the safety of the community, or to ensure the safety of the community, ensure a defendant that comes back to court is what's required under the law. Here, we have no history at all of failures to appear, and no criminal history whatsoever. These are only allegations. There's a presumption of innocence. I think it would be inappropriate and congruent with the wishes of the legislature and the will of the people to hold Mr. Bivins with $75,000 bail. I would ask for conditional release, no objection to reporting requirements. I'd like to give him the opportunity to demonstrate that he can comply with basic court orders and make his court appearances. If Your Honor is disinclined to order conditional release, I think $75,000 is far too high. The only rubric when determining what an appropriate bail amount is that a court should take into consideration should be the likelihood of him or her returning to court, and should not be related to public safety concerns. Those can be addressed through conditions of release. So I would ask that if Your Honor does not order conditional release, that Your Honor set the bail at something that I would ask for $5,000 bail, given the total lack of criminal history, the total lack of failure to appear history.
I understand. The concern for the court is what appears to be a systematic targeting of members of our community who have suffered historically, and that there is this just what appears to be a kind of targeting of these communities to instill fear, and that is profoundly disturbing based on the allegations. I recognize that there are rights that Mr. Bivins has, and that Mr. Bivins doesn't have a criminal history and has, as you've mentioned, no FTAs, which is to be considered by the court in kind of making these determinations as to whether it's appropriate for his release. What is concerning, as pointed out by Mr. Gibbs, is that within the statements he appears to have not been slow, or at least his statements would raise concerns for the court as to whether this alleged behavior would continue. And as such, I will impose a $45,000 bail amount, and if it he is released, he's not to be within 150 feet of those victims or the locations where these events occurred. And Mr. Gibbs, do you have either the addresses, or could you please put those names of those organizations on the record once again?
Yes, Your Honor. That is Congregation Beth Israel, Congregation Shir Tikva, Everybody Eats PDX, and the Muslim Community Center of Portland.
All right, thank you very much.
And Your Honor, I additionally requested that he report to closed street if released for any reason. Is the court ordering that?
I am.
Thank you, Your Honor. And to the victim representatives who appeared on WebEx, that's the conclusion of this hearing. I'd strongly recommend you contact the case deputy, Mr. Zemmel, or the victim's advocate on the case to discuss in more detail what the case is going to look like moving forward from here. Thank you for being present.
Yes, I am appointing counsel. Counsel will be Mr. Tran for the record, and at which time Mr. Bivins can make a determination after discussing the case with Mr. Tran.
Next court date, May 17th at 9:30, back here in GC3.